in this regard. Now, the particular issues that the evidence leaders would want to canvass with Mr. Mokoena and Mr. Jamieson are set out in Chapter 5 of the Phase 2 report. It's only it's less than 8 pages, but never mind that. The Commission follows a practice in terms of which witnesses are given notice of the particular documents with which they'll be confronted in cross-examination. It's more than 2 weeks before Mr. Mokoena or Mr. Jamieson will testify, and in the circumstances we submit that there'll be no unfairness to either of them or to Lonman if they're subjected to questioning on Phase 2 issues.
Now, sometimes, of course, notice of these documents is given very shortly before the witness testifies. Now, have you any suggestions in regard to the fixing of it, on the assumption that your application is granted, the fixing of a time by which notice of documents to be relied on in cross-examination should be given? Well, I can understand Mr. Mokoena and Mr. Jamieson might well be very embarrassed if they were cross-examined on a massive document of which they only got notice a day or two before.
Well, in relation to Mr. Mokoena, we could give notice before the end of this week, which would be 2 weeks before he testifies. In relation to Mr. Jamieson, we have a slight difficulty because we have addressed a request to Lonman for the documents relating to the payments made to Lonman head office and the payments made to the Bermuda subsidiary, which is Western Metal Sales Limited. Thus far, we haven't received those documents from Lonman, so we can't identify which documents we'd want to put to Mr. Jamieson until we get the documents from Lonman itself. But we can turn it around within 48 hours.
To be fair, that it may be that depending on the documents you get in relation to that issue, you may not wish to proceed with the cross-examination.
That is also a possibility. But Chairperson, whatever the situation is in relation to Mr. Jamieson, certainly in relation to Mr. Mokoena, we can't see any unfairness in his being subjected to cross-examination on those Phase 2 issues. And if Lonman responds to our request for the documents that we have identified as necessary for our inquiries with Mr. Jamieson, I hope that we'll be able to reach a fair arrangement in relation to his cross-examination as well. So, those are our submissions. We'd ask you to withdraw the ruling. We would tender to provide Mr. Mokoena with a list of all documents on which we would want to cross-examine him by the end of this week, and within 48 hours of being given access to the documents we've requested from Lonman in relation to the payments to head office and Western Metal Sales Limited, we would give notice to Mr. Jamieson of any documents we would want to rely on in cross-examination of him.
I didn't my microphone on. You tended to give Mr. Mokoena a notice of documents to be relied on in cross-examination. By the end of the week.
Which would be a clear 2 weeks before he testifies.
And as far as Mr. Jamieson is concerned?
48 hours after we receive the documents that we've requested from Lonman.
But if you're going to persist in that point.
Indeed.
Yes, thank you. Obviously, I'm going to call on you to reply, Mr. Berger, but let me find out before I call on you to reply whether any of the other parties, there was a suggestion that some of them might want to speak on this point as well. I think it's only fair that those who wish to support the application should get a chance to speak first, and you should get a chance to reply to them. Those who wish to support the stance to be adopted by Lonman can obviously speak after you've spoken if there's anything left that they consider it necessary to say. So may I inquire, which parties wish to, if any, wish to address the Commission in regard to the evidence leaders' application?
Yes, Chair. Num.
Num, right. That's Num. May I ask whether you're going to support the evidence leaders or support Num?
Support. Well, certainly support Num.
No, sorry. Oh dear. I'm sorry to be so tired so early in the morning. Are you going to support the evidence leaders or support Lonman?
We'll support the withdrawal of the ruling separating phases 1 and 2, and then if I may make one or two comments on that.
You would speak then before, Mr. Berger?
Yes, I believe so.
Any other party wish to speak?
Yes, the Legal Resources Centre. Yes, Mr.
Which side of the debate will you be?
Against Lonman.
Against Lonman.
Yes.
And Chair, the human rights.
I think it'd be more sensitive to say against the arguments to be advanced by Lonman.
In favour of the arguments to be advanced by that have been advanced by the evidence leaders. Yes.
Okay. Mr. Rue, I see you turned your line.
Yes, the Human Rights Commission would also like to address the Commission.
On which side?
Aligned with the LRC's position.
I see. I would say you also would speak before Mr. Berger, so he'd get a chance to deal with what you have to say.
Yes, Chair.
If he considers necessary to do so. Anybody else wish to speak? Mr. Mpofu.
Yes, thank you, Chairperson.
What side are you going to be on?
Well, you'll be surprised, Chairperson.
Nothing in this commission surprises me.
I know. Chairperson, I don't think one can strictly say which side we're supporting.
All I want to know is, do you speak with Mr.
Yes,
we speak before Mr. Berger or after?
After.
Does that mean...
Because ours is just a short statement, Chairperson, which just wants to put across our position.
No, I understand that. And look, I'm not trying to pin you down, but I'm trying to be fair to Mr. Berger. If you're going to say something which Mr. Berger may wish to deal with, then it's only fair you should speak first.
No, I'm sure Mr. Berger will be pleased by what I'm going to say.
I see, all right. Mr. Berger, so I'll put you on the other side of the column. I and AP, you said. Mr. Ntebeza?
Mr. Chairman, I'm not so sure that we are going to be making a statement, but we are supportive of the evidence leaders. All right. So I'll put on behalf of the AMCU and the families.
I'll put you in the evidence leaders column in my notebook. Are you speaking on behalf of the families? Did you talk about AMCU as well?
And AMCU as well.
You're going to speak on behalf of AMCU as well?
Yes.
All right. Anybody else?
The police is on.
The police? Are you sitting this one out, Mr. Semenya?
We're making no address, Chair.
All right. Anybody else? No. All right. Mr. Tip.
Thank you, Chair. I address principally the question of the ruling separating phases 1 and phase 2. And we support the withdrawal of that ruling, and I should like to indicate very briefly why that is. And it is essentially because it has, as the Commission will be aware, been our position throughout the course of these proceedings since October 2012, and remains the case now, that we do not see any fundamental reason to maintain a distinction between phases 1 and 2 in the light of this particular perspective, which is the one that we have sought to articulate previously, namely that although it may be conceptually and practically useful to have evidence divided into phases 1 and 2, ultimately there is a single standard that has to be brought to bear on that evidence, irrespective of whether it's phase 1 or phase 2, namely the criterion of relevance. And that criterion is necessarily a function exclusively of the terms of reference that govern the work of this Commission. So, in other words, we respectfully see no functional reason to maintain a distinction where there is ultimately one criterion that must address both. Now, that's the essence of our position. Chair, I want to add a few remarks about the preliminary report. In the email that we received yesterday, we were requested to make any submission that we thought appropriate in respect of the approach of the evidence leaders that is set out in this preliminary report. And although, of course, there has been precious little time to give proper consideration to it and to the various questions that might arise, it may be of assistance for me just to outline in essence what we feel that we can say at this stage. This preliminary report consists of 4 substantial chapters, and I want to make just 1 or 2 comments about each of them. The first chapter of consequence deals with the composition of the strikers on the Kopi. And that, as my learned friend Mr. Chaskelson has indicated, sets out in some detail a material that essentially was obtained from Lonmin and, in our view, very usefully and necessarily informs the Commission on just who the strikers were on the Kopi. And a number of different perspectives have been set out there. It won't be helpful for me to summarize what is in the chapter, but that is essential information in our respectful submission that the Commission and all who read its report in time should understand just who the strikers were, where they come from, helpfully in that analysis. So we consider that to be
so you better repeat what you said, and then I'll ask you a question.
Sorry, I nudged the button on the mic. I had just wanted to perhaps repeat that the information that has been gathered in Chapter 2, dealing with the composition of the strikers on the Kopi, is patently, in our view, very pertinent and very relevant. And it gives a proper understanding to who those people were, and, for example, gives some deeper understanding of why it is that the people on the Kopi responded, for instance, differently to Mr. Zokwana and to Mr. Matunjwa. All of that leads to an enrichment of a grasp of what was happening. In other words, that chapter very comfortably satisfies our view of relevance. So too the next chapter, which deals quite extensively with the lived experience of underground workers. It also, from a somewhat different tangent, but in our view with equal cogency, describes more fully, for those who are concerned with a proper understanding of these events, what the lives were of the people who were involved in these events. And that too, if I may use the word again, enriches one's understanding of the dynamics of the interaction in a way that we consider to be pertinent to a proper discharge of the terms of reference. It may be, as my learned friend Mr. Cheskerson has said, that there may be some queries in respect of particular aspects that Lonman may have. Well, if that is so, then we align ourselves with the consideration that that should be clarified and that can then be evaluated. The third chapter is one...
You're now dealing with Chapter 4.
I'm now dealing with Chapter 4, Chair, which is entitled Lending and Debt Collection. Now, that is a subject that we have previously touched on incidentally in the course of various debates in relation to the question of phases 1 and 2 and the terms of reference. And that is a chapter concerning which I would, with respect, want to just place a cautionary question mark over, and I deliberately don't want to make a submission that is in any stronger terms than that. And the caution is this, that when one reads that chapter, a number of substantial banking institutions are identified by name, and there is also an analysis which goes around the topics of matters such as unscrupulous lending practices, reckless lending, garnishee orders, the manner in which repayments are enforced, and matters of that kind also are clearly part of the lived experience of a great many mine workers in the Marikana area, and of course elsewhere in South Africa. The caution is...
Sorry, I'd like to ask you, I've just now been handed a copy. I see there's reference to the U-Bank. Am I correct in understanding that that's partly owned by NUM? So is that the source of the relevance of your complaints, possible complaints in relation to this chapter? Am I correct in saying the U-Bank is half owned by NUM, or indirectly half owned?
There's a very indirect connection, but that doesn't concern me at all, Chair. That's not a major bank, but what I'm saying is the caution. I'm not defending NUM here. I'm defending the integrity of a chapter in a report that the Commission will need to consider. There are other more major banks involved, and they're identified by name. The caution is simply this, that if a chapter of that kind were to find its way into the ultimate conclusions of the Commission as a whole, then it may be that institutions of that kind will query how they came to be the subject of a finding which is at least inferentially prejudicial. And they would want to know how that arose out of the terms of reference, and they would very likely want to know how it was that these findings and remarks about them have been made when they have not at any time been a party to the proceedings. All of that entire chapter consists of matter that hasn't been ventilated, as far as I know, in the course of these proceedings in public at all. So, as I say, deliberately, it's a cautionary question mark.
I see. What you are, if I'm endeavouring to summarise what I understand you to be saying, is that we must be cautious in relation to this chapter, and it may well be that we should, out of considerations of fairness to financial institutions implicated in the chapter, possibly exclude that evidence from consideration. Alternatively, only rely on general statements without identifying particular institutions. Would that be correct? Well, I can understand an argument.
Yes.
I haven't read this chapter at all, but I can understand an argument that, I don't know, it will be put up, but it may be put up, that the housing is irrelevant. The deplorable housing conditions which we saw when we went on our inspection in October 2012 were somehow not related to the assertion, which presumably, which is certainly made by some people, that created a tinderbox, so one spark caused not all, but caused a substantial degree of trouble. Now, the argument may well be put up that those deplorable housing conditions are not causally connected to what happened, but that the facts set out in the previous chapter, the financial implications of reckless lending, garnishee orders and the way they're administered and so on, are. So it may well be that London, for example, may well wish to rely on the content of that chapter if the ruling is reversed.
Well,
I'm just thinking aloud now, perhaps unwisely, but that's the point that I think I should put to you so you can deal with it.
Chair, yes, in broad terms with respect, those are precisely the kinds of concerns that I'm trying to articulate, that there may well be ways of dealing with that information that neutralize the role players, but still capture some of the essence of it. Subject, of course, always to the overriding consideration of whether or not that material is, in any event, of sufficient relevance in respect of the events that form the subject matter of the terms of reference, so that the notional bank about whom I'm postulating a possible response may say, well, whatever you have to say about lending practices, how did this cause deaths in the course of this week of the 9th to the 16th of August 2012? So that also is something that one would need perhaps to put through the process.
But what I was really putting to was that if we decide to reverse the ruling, if we don't, then the problem falls away. But if we decide to reverse the ruling, then there might well be questions of relevancy in regard to some of the contents of this report, which would have to be considered at that stage. That's your point, isn't it?
That is perhaps the absolute essence of what I'm submitting to you this morning, Chair, that the removal of the notional distinction between phases 1 and 2 in effect enhances the applicability of what is in any event an overriding criterion, namely relevance. So that has to be the guiding star in respect of the evaluation of any material.
What you've said, I think, quite clearly, is you support the application by the evidence leaders, but you caution us that if we go down that route, we will have to concentrate very carefully on this question of relevancy. Is that a fair summary of what you're saying?
With respect, precisely.
Particularly, I think only really so far, in relation to Chapter 4.
That sort of enterprise. It's the only chapter of its kind in this preliminary report, but it may be something that bears another material as well, yes, either directly or indirectly.
What do you say about Chapter 5?
Chapter 5 is a chapter that we're really not in a position to say anything about. And that is because it deals very substantially with interaction between Lonmin and the evidence leaders. We're not privy to a great deal of that, and it would, I think, be wrong for me to stand on one side or the other of that particular difference. So those are our submissions, Chair. We hope that they may be of some assistance.
Yes, thank you, Mr. Tip. The next is NUM. Sorry, you NUM. Sorry, I beg your pardon. NUM. LRC is next.
Thank you, Mr. Chairperson. We have written submissions. I just wanted a copy to be given to Lonmin. 2 copies.
All right.
But we've handed up to the panel, as I understand. What happened?
Yes, Mr.
Yes.
Okay. Mr.
Nukai Toby, Mr. Chairman.
I know. I'm trying to get my tongue around it, but it is in Nukai Itobi.
Yes, indeed.
And you've handed up your heads.
Yes, I did. There is a substantial...
No, I don't. It's 14 pages. I presume you're not going to read them out to us. But
no, I don't intend to, Mr. Chairman.
You've given a copy to your learned friend, Mr. Burke.
Yes. At any rate, there is a substantial overlap between what is said here and what Mr. Chaskalson said on behalf of the evidence leaders. I just want to cover aspects that I believe require emphasis. The first relates to the question of the mandate of the Commission, which is dealt with in page 2 from paragraph 5 onwards. There is a suggestion in the objection by Lonmin that there is a possibility that an inquiry into phase 2 might trespass the terms of reference. We argue there that there is no such a possibility. In fact, quite the contrary. It is clear that the topics that are covered in phase 2 constitute an essential part of the terms of reference of the Commission. And if that is the starting point, then it is upon Lonmin to illustrate why an item that belongs in the terms of reference should nevertheless be excluded from consideration by the Commission. In fact, if the Commission did not attend to a matter that falls within its terms of reference, the Commission itself might well be acting outside its terms of reference and hence unlawfully. The next issue that we want to deal with is from paragraph 10 onwards. And this is this. We are not asking for an open-ended inquiry into Lonmin. We are asking for a specific inquiry into specific topics. And that is determined through 3 criteria that we set out at paragraphs 10.1, 10.2, and 10.3. And the first criteria, and that's the position that was taken by Mr. Tip, is relevance. So in other words, the evidence that belongs to phase 2 must be relevant to the terms of reference. But in addition to relevance, the evidence must show causation at paragraph 10.2. And then there's a third and final element, which is that the evidence must show legal responsibility on the part of Lonmin. We have chosen these three in order to limit the scope of what is called phase 2 to the issues that will constitute not just the part of the terms of reference, but also will meet the test of relevance in a much narrower sense. So that, Mr. Chair, if evidence is led which does not meet the three criteria of relevance, causation, and legal responsibility is led, it will be up to the panel to exclude that evidence, and it will be up to the panel to refuse any request for cross-examination which do not meet this criteria. We have dealt with the issue of fairness to Lonmin, and Mr. Chaskalson addressed that. I don't intend to repeat it, except to say that we support in full the submissions that have been made. Another point that's taken by Lonmin relates to what has happened in relation to witnesses which have given evidence to date. Particularly, Lonmin contends at page 3, paragraph 4.6 of its letter, that witnesses who have testified to date have not been cross-examined on its policy, procedure, practice, and conduct relating to its employees and organized labor. We say at paragraph 17 that in fact the evidence has covered those aspects. There have been extensive evidence led and cross-examination on issues about organized labor and how Lonmin did not, in fact, deal with the matter as it should have. One of the examples is a statement given by Mr. Da Costa, which traces the genesis of the dispute to the events of May 2011, particularly the situation at the Career Mine. And it places it in two factual issues. The first is the general unrest in the Platinum Belt as a whole, so that Lonmin should not be seen in isolation. And then the second is the strike of May 2011 at the Career Mine. Those are not, strictly speaking, phase 1 issues in the sense that they do not deal with the responsibility of the police. And those are, in general terms, phase 2 issues, but they have been allowed, and they have continued to be allowed. So what I'm trying to say, Mr. Chairman, is that phase 2 has always been alive. And if Lonmin complains that they have not had an opportunity to prepare properly for phase 2, well, that is their fault. So, Mr. Chairman, if phase 2 has remained alive, there were two additional points that were made at the time of the separation. The one was that there will be consideration given to phase 2 being given by way of affidavits. But even when that provisional ruling was made, it was always clear that the Commission will reserve the right to call specific witnesses of Lonmin to give evidence on oath. So they should have prepared for it. Then, Mr. Chairman, I want to deal with the issue of whether Lonmin is being singled out in isolation, because that is one of their complaints in their letter. The problem with
paragraph 19 of your heads.
Yes, paragraph 19 of my heads of argument. The problem with this complaint is twofold. The first is that we have not heard the full version of Lonmin. We've only heard, I think, 2.
How many witnesses?
Yeah.
Well, we've heard 4.
Yeah, 4 witnesses.
Yes, we've had more than 2. Yes.
4 witnesses, but the full version is yet to be spelled out by Lonmin. Particularly the 2 witnesses that are pertinent to the so-called phase 2 questions, Mr. Jamieson and Mr. Mokoena, have not yet given evidence. So they have enough time to prepare in relation to phase 2 questions. But, Mr. Chairman, what are these phase 2 questions that the LRC intends canvassing? We have isolated 3 topics that we say meet the criteria that we have suggested. The one is housing. We covered some of this ground in relation to the evidence of Mr. Ramaphosa. You will recall that some of the questions were deflected to Lonmin. We were told that management will give us responses to these questions. The second area is in relation to the social and labor plans of Lonmin. Mr. Chaskalson has already addressed the Commission that this is not an act of charity on the part of Lonmin, but it is a legal obligation flowing from the legislation. But there is a third element.
It's further than that, isn't it? It's a legal obligation which was a counter-obligation to the acquisition by them of certain new order rights. They got new order rights inter alia in exchange for obligations to address issues of housing and so forth in the manner set out in the social labour plan. Is that correct?
Yes, that is the submission, Mr. Chairman. The issue of housing has been dealt with extensively by Mr. Chaskalson. We dealt with it in brief with Mr. Ramaphosa last week. There is a third topic, Mr. Chairman, and I know I was excluded when I tried to cross-examine on this question. But now that we are dealing with the opening or reopening of Phase 2 in full, I want to put this back on the agenda. And this is the issue of the shareholding of employees, particularly in the form of employee share schemes. What we were able to find in our examination of the reports by Lonmin is that what transpired in 2010-2011, 22,000 workers that were employed by Lonmin were previously made owners of the business of Lonmin via an employee share scheme. That was taken away in 2011 when Shanduka acquired the 9% stake in Lonmin. This is an issue that is pertinent to us because not simply to show that Lonmin did not comply with its obligations under the BEE legislation, but to show that if workers remained in part owners of the business, this is an issue that would have been relevant to their social conditions. And that at the time that a decision was taken that their stake should be liquidated so that by 2012, when Shanduka became the sole BEE partner of Lonmin, workers were no longer in contention. The point that we want to make here in relation to the shareholding, and that is why we want this issue to remain alive in relation to the topics, is that one way of dealing with labor discontent is extending shareholding to workers. And that one of the responses that could legitimately have been given by Lonmin to the very demands on the strike is that the workers themselves remained part owners of the business, and that depending on the fluctuations of the price of platinum at a future date, they could in fact earn dividends qua shareholders in Lonmin. So our submission, we've made the submissions in relation to what criteria should be used to allow Phase 2 evidence. But we also want to make submissions on the substance of the Phase 2 issues so that it's not an overarching and never-ending inquiry. There are three topics that we say are relevant here: social and labor plans, housing and obligations, and the issue of the shareholding. So in conclusion, Mr. Chairman, we say that it is clear that Phase 2 forms part and parcel of the terms of reference of the Commission. We say that we have proposed a practical way that would accommodate every party and that will lessen the unfair impact of Lonmin in terms of how to distinguish between an issue that might be a Phase 2 issue but not relevant for purposes of this Commission. And we say that we've also suggested three topics that the LRC intends cross-examining on. So with those submissions, we say that the application by the evidence leaders, subject to the qualifications we have given, should be granted.
Yes, thank you. Ms. LaRue, I think you're next.
Thank you, Chair. Chair, I do intend to address you on the withdrawal of the ruling and its effect, but first I do think it's important to have on the record that we need to take a step back and record again why the Phase 2 questions are so important. And it's that only when we understand these systemic issues and questions that the opportunity that this Commission presents could be seized to really understand what led to the killings, but it's the investigation of all of these surrounding circumstances that Phase 2 was meant to encompass. Of course, Chair, the Phase 1, Phase 2 ruling unquestionably had utility and has utility in the Commission process, that we were able to focus on the policing questions. And as the Human Rights Commission has always understood the ruling, it was always the intention that the two phases would run in parallel and that the Phase 2 issues would receive the necessary, sufficient and satisfactory attention that they deserve.
So it's not correct to say that we were enabled to focus only on the policing issues. There were other issues which were also relevant in relation to the conduct of the strikers, which preceded the events of the 16th, which also been covered in evidence, also very relevant also. It would be unfair to suggest that only the police have received, their conduct has received scrutiny. Other parties have as well, and the unions and so forth also. And also London too, to the extent that it will be contended, as I understand it will be, that their obduracy and their refusal to negotiate was part of the problem. But so it's not fair to say have only been looking at the police so far. We've looked much further than that.
Correct, yeah. I've used the policing theme as a shorthand, which, you're correct, does not capture that Phase 1 focused on the events of the 9th to the 16th of August and the roles that the various parties played in those immediate days that led to the tragedy of the 16th, and Phase 2 rather relates to the surrounding circumstances and actions by various stakeholders that gave rise to some of the material conditions that made the strikers go to the Kopi, seek a wage increase, and the various roles that all of the other stakeholders played in those demands. But to return to the utility of the ruling, it was always the Human Rights Commission's understanding that the two phases would run in parallel and these questions would receive the necessary, sufficient and satisfactory attention. And Chair, I hardly need to remind you that since December 2012, the Human Rights Commission has repeatedly written to you, recording its concern that there seemed to be a deprioritization of some of these Phase 2 questions. And, throughout 2013...
We received, but we didn't agree with the comment because it was always intended to look at the Phase 2 questions. We were looking at the time at the other issues that we were looking at directly. And it was a matter of approach. We just differed from the Human Rights Commission. We received those letters and we, I think, indicated that we didn't agree. But anyway, that's not an avenue we need go down now.
Of course, Chair, and obviously we were seeking to assist the Commission to try to understand what the procedure would be to dealing with the Phase 2 questions. My learned friends have referred to the question of whether it would be oral or written evidence, how much time would be allocated to these, and then the scope of the Phase 2 themes themselves. In addition, throughout the period since the start of the Commission, the Human Rights Commission has sought discovery through the Commission process, from Lonmin as well as...
I've always thought that Phase 2 would definitely involve a different approach and would far more be devoted to examination of documents and objectively ascertainable facts. I wasn't prepared to sit for a week hearing evidence about how many hostels there were and how many houses there were, with lengthy cross-examination by some of the cross-examiners who've excelled in lengthy cross-examination on topics of that kind. I would have thought that we could find out how many houses were built, just to take the housing as an example, as a matter of objective fact by looking at the London documents and how many houses are built. So, though there are important issues to be covered in Phase 2, even what's left, many of them are susceptible of being solved by reference to documents and objective facts rather than disputes of fact as to who shot whom when.
Yes, Chair, and in order to assist the Commission in ascertaining those objective facts relating to the Phase 2 themes, the Human Rights Commission made requests to Lonmin, to the Department of Mineral Resources, to the Madibeng and Rustenburg local municipalities, as well as to the Bapo Bamachale leadership. We obviously understand the Commission's reluctance to compel production from these parties, but what that has meant is that we now find ourselves under significant pressure, probably constrained to only deal with Lonmin-related issues, and being asked to do so in the 5 weeks that remain.
Isn't that largely the result of the deletion of paragraph 1.5 of the terms of reference?
Well, Chair, given that our discovery to these other parties related, obviously in part, to Lonman's role in the communities, it was, there would have been responsive discovery if we'd been able to get it out of these entities that would have assisted even in the themes that remain for the Commission's attention. Chair, I must confirm again that the Human Rights Commission intends to assist the Commission to the limited extent that it's able to in the remaining time. As you're aware from the correspondence addressed to the Commission on the 4th of August, we are finalising submissions that relate to Phase 2 questions, specifically an analysis of the SLP system, the entire regulatory and legal framework that sets up those obligations and that system, as well as a limited analysis of Lonman's compliance with its obligations under the SLPs, in addition to the housing obligations that have received some attention in the Commission process. But of course, these are incredibly limited submissions, limited due to the lack of discovery by Lonman, as well as the lack of time to be able to do any meaningful analysis when we only received discovery from the DMR and from Lonman in the last 2 weeks. In addition, we intend to make a submission relating to the corporate accountability framework in which Lonman's conduct could be assessed and evaluated by the Commission. Those submissions should be, they're in the process of being finalised, and they will be with the Commission, we hope, by the end of the week. So, Chair, given the limitations and the significant limitations...
If they're going to call for an answer from Lonman, it's obviously important that Lonman get them as soon as possible, also if we're going to change the ruling.
Yes, Chair. So, Chair, given these significant limitations of time, discovery, the available hearing time, and whether we will have the correct witnesses before the Commission in its programme, we ask the Commission, in essence, to try to salvage what it can from the missed opportunity that is, unfortunately, Phase 2. We hope that the ruling on the withdrawal of the ruling will enable the Commission to do the best that it can, because in essence, whether the ruling remains in place or not, we face these significant limitations in terms of the record that is available to this Commission, as well as the time available and the resources of the parties available to delve into these questions with the necessary depth and detail. But again, pragmatically, we encourage the Commission to try to salvage what it can, and will continue to assist the Commission to the extent that our team can when these questions come up in the remaining 5 weeks. Thank you, Chair.
Yes, thank you. The next party wishing to address us on this matter, well, there are two who are going to address us simultaneously, as it were, the families and AMCU. Mr. Nsebeza.
Chairperson, before Mr. Nsebeza addresses you, can I ask that you reconsider the sequence? I think it
all right, okay, if you want to argue now, then
no.
This is an appropriate stage for me to, you are now addressing us, to express our congratulations to your attorney, Mr. Platler, and his wife, who I believe were blessed with the birth of a healthy, bouncing daughter yesterday. And I'm sure all of us here involved in the Commission will wish to express our pleasure and congratulations to them, and wish them well in the years to come. Yes, after that non-controversial note, what would you like to say, Mr.
Thank you very much, Chairperson. That is very kind. We appreciate that. What I wanted to say, Chairperson, was if I could speak before Mr. Berger, because although, as I said, some of the things that I'm going to say might please him, some might not. So that he can have...
If you're going to say things that he may wish to answer,
yes,
it's appropriate you speak before him. And that... So on that point, the question, only remaining question, is whether you should speak before Mr. Nsebeza.
No, certainly not.
Let us allow Mr. Nsebeza to decide that matter for us.
Thank you, Mr. Chairman. Mr. Chairman, I had indicated that we may not...
No, you're not understanding me. The question that arises for us to decide now is whether you're going to address us before Mr. Mpofu. And I say, I have to decide that, but I'm delegating to you the responsibility of deciding that issue for me.
I always defer to Mr. Mpofu. We've agreed that... Mr. Chairman, There are just one or two things that I would like to deal with, which arise out of the submissions that have already been made. The first one is simply to state that phase 2 issues are matters AMCU and the families, and more particularly AMCU, would be keen to have ventilated in the context of your terms of reference. And that should be obvious in its own terms. The housing issue has been a burning issue. It continues to be a burning issue for AMCU. And the question of reckless lending, which has been alluded to by my learned friend, Mr. Tip. We certainly do not share NUM's diffidence that, for instance, some of the issues that are covered under the head lending and debt collection may not have a bearing on the tragic events that took place during the time that the Commission is considering the events between the 10th and the 16th of August. I think either in a nuanced form or even in a direct form, there would be an argument that could be made to show the relevance of those machonisas or the lending schemes in relation to which the chairman talked about Ubank and the tragedies that took place, particularly on the 16th. So we are of the firm view that
the Council for NUM was addressing us at the time, and
yes,
I wondered whether that was why NUM was concerned in that issue, but he assured me that that wasn't so.
No, I heard also his response. He tried to downplay the relevance of NUM's participation or shareholding in Ubank, and the view that we may take that Ubank, in fact, is not a far distance from our bill, which has been in the news in the recent past, as Mr. Chairman will take judicial notice thereof.
We're going to go there, Mr.
We won't go there, Mr. Chairman. But I'm just citing it as an example. But having said that, you see, if it is so that the National Union of Mine Workers had a shareholding in that bank, then it is relevant, especially in the context of what happened. And some of us have always held the view that there is running throughout this entire commission an intersection between state, labor, and obviously the capital. So it is a topic that it would be tragic if the Commission were not able to deal with, simply because of the opposition that has been put up by Lonmi. I mean, Mr. Chairman, further, Mr. Ngogai Toby's submissions on not just the liquidation of mine workers' shareholding in Lonmin, but critically to whom those shareholders eventually ended, is a matter of grave concern. The Deputy President of the Republic of South Africa is key and central to the consortium that took over those shares. And if no inquiry could be made into how the transaction took place, how ordinary workers, qua shareholders in their own rights, ended up forfeiting those shares, and how those shares ended up in a consortium led by one who now is the Deputy President of the Republic of South Africa. If we could not inquire into that, then it would be self-defeating, And as far as
the question of the relevance of such investigation will only arise if we reverse the ruling and proceed with phase 2 issues as well. Alternatively, if by some process we're able to finish phase 1 in time to deal with phase 2 separately, the issue could then arise. But what I'm putting to you is that in either of those events, the second is unlikely, I think, without being had to the time that's elapsed and it's still available. But it's a question of relevance, and that question of relevance doesn't arise for decision at this stage.
Yes, Mr. Chairman, as Mr. Chairman always does, you have read my mind because that was going to be my next submission. And my next submission is that I find myself in a cleft stick precisely because on the one hand, I do appreciate the fact that there is very little time left. And for that reason, I have firm instructions from the Socio-Economic Rights Institute to support the evidence leaders' application for a revisitation of these so-called phase 2 issues. Mr. Chairman, it must be remembered that when the division between phase 1 and phase 2 was arrived at, was agreed, it was not because there was any expression at that time that it is irrelevant or it is not in terms of the terms of reference that inquiry should be made. It was purely for procedural convenience that there was this view that phase 1 and phase 2 issues can be dealt with in that kind of way. The fact of the matter, of course, now the reality is that we have come to virtually the end of our life. The issues that have been raised are so critically important, and I've just raised 2. And it seems to me that and I think Mr. Mpofu will deal about this more appropriately. If it is so that in terms of one of the clauses of the terms of reference, this commission is able to determine a portion or an aspect of its own inquiries to another body to deal with, that probably would be what the commission could do. To say this aspect must be referred to another commission, possibly chaired by you, Mr. Chairman.
You were offended by Mr. Zipez. I realize I was possibly wrong. But I hear that
with different evidence leaders, Mr. Chairperson.
Mr. Chairman shouldn't opt out. But, I mean, in a more serious vein, if it is so that your terms of reference allow you to make a recommendation that a particular aspect, and this aspect, a phase 2 aspect, is something that can be referred to another inquiry, then perhaps that is something that would be preferable, because it is in the interest of dealing with that aspect very thoroughly and with a little bit more time than the remainder of the period in the life of this commission would allow for the matter to be dealt with in. My problem, of course, is that if any commissions I've been involved in are anything to go by, when once recommendations are made, then it's out of your hands. And that day may never come. And we would have missed an opportunity of dealing with...
Do I understand you to be saying this? If I'm misunderstanding you, please correct me. What you're saying is we should start with some of the phase 2 issues. And if, however, we find at the end that we haven't been able to deal with them as fully as they require, then we could recommend that a further commission be appointed. But if we feel that we're able, with the material before us, to make certain definitive recommendations, we should do so. But it would be premature at this stage for us to assume that what the position will be. But certainly, to be in a position to make recommendations for a further commission, for example, if that were to be the route to go, it would be necessary for us to have, if possible, some evidence, the sort of points that would arise before such a proposed commission. Is that so?
And Mr. Chairman, I couldn't have put it better myself. I think that's the summation of what I'm saying. Rather have, in the little time that we have, something on the basis of which we can either make substantive findings or to make the recommendation that some other commission must deal with it. Those are our submissions, Mr. Chairman.
Been drawn to the fact that it's now 10:30, so perhaps we can defer the pleasure of hearing Mr. Mpofu after we've had the first comfort break.
Thanks, Jefferson.
Chairman, please.